Good afternoon. This is Alan Gassman, joining you who have already joined us at our second webinar. This one is Protecting Medical Practice Assets from Creditors, General Strategies and Common Mistakes. And the first mistake I'm not going to make is keeping you later than what we said we were going to keep you. We're going to be done here at least by 5:30. We may take a couple questions just before, by 6 o'clock. We may take a couple of questions before then. But hopefully you'll gain a lot of knowledge here and not get tired of the presentation. We do welcome questions, but the best way and the only way I'm really technically able to take a question would be if you'll just type it out, and I'll be reading the questions while we talk. At the end, we may be able to take oral questions, but I'm not sure we can. We do have a banker with us, so if there's any bank questions of your banker, we have Eric Mooncheck from SunTrust, who's helped some clients recently. If you have questions, I'll be glad to send you Eric's number. Very bright guy, and he's pretty much in tune, very much in tune with what we do here with physicians. There are other bankers who are very well in tune as well, but at least he's one of them. If you can't hear me very well, then you will want to call in. If you're listening to me on the computer and the sound doesn't sound very good, I can assure you my voice sounds great. So it's got to be your system. And we just know from experience that if you call in, you will hear us fine. I'm going to follow the PowerPoint presentation. There are 3 documents that you have access to. The only one you really need for today is the PowerPoint presentation. There is a separate follow-up checklist in case you want to forward it to somebody. That follow-up checklist is also in the PowerPoint presentation, so you won't need to print that out or have it open separately. And then there is an outline which is derived from a March presentation that I gave for a national program on planning for physician practice protection, which you may find to be of interest. If anyone would like to get a copy of the entire B&A presentation that we gave in March 2010, I'll be more than glad to send it to you. So now on the screen you see the red ball surrounding August 3rd, 2010, and I'm going to flip the page, and the first thing we're going to see is the follow-up checklist, because if we're successful here today, not only will you have some new knowledge or maybe some assurance that you are on pretty safe ground, but also maybe some follow-up. And if you want to do follow-up, you could put a check mark if you've already done the thing in question, or if it needs to be done, or if you're not sure, which is often the answer. And if you're not sure or it needs to be done, who are you going to delegate this to? You might even, if you delegate this to 6 different people, you might just make 6 copies and circle their name and send them this checklist. Just might be helpful. If we have time at the end of the presentation, I will go over the items in the checklist, but I think you will find them self-explanatory from the presentation. Now, whenever I address lawyer groups and CPA groups, we talk about different physician representation objectives. And I think a very important one is number 1, maintain and appropriately use independent professional advisors. The biggest mistakes that I see are when physicians don't have a balanced team of a good CPA, a good lawyer, a good insurance advisor, and a good banker. Anyone who's trying to call all those shots for you at one time is probably not good at wearing any of those hats, even if they think that they are able to. Number 2, having proper malpractice insurance. Number 3, having the other right kind of insurances, which we'll talk about in a little while. Number 4, appropriate buy-sell and shareholder agreements. Number 5, and this is probably the primary purpose for you joining, to try to make the professional practice and the doctors hard to get to, so that if there's a malpractice action, the plaintiff's lawyer and the plaintiff are more than likely to settle for whatever they can get from the malpractice carrier and not have a clear pass into the doctor's assets or the medical practice assets. Number 6, optimize what you can put into a tax-deductible retirement plan, and that's going to be more attractive next year when we see our personal income tax rates go up, if they do. Number 7, comply with the health care laws. We've had our share of clients who have had to shut down practices and basically go out of the medical business because of problems with health care law compliance, so we don't want to take that for granted. Number 8, are you theft-proofing your monies and your accounts receivable? We do almost every year have a client who calls up quite exasperated when $80,000 to $200,000 of money has been taken by somebody working in their office. And number 9, safeguarding life insurance investments and savings. Going to page 5, I'm not going to belabor the choice of the CPA, just suffice it to say that I think that that is the most important player on the team most of the time. When you're not in crisis mode, that CPA, if they know what other physicians do and they're pretty well grounded in these rules, they're the ones that you might meet with every 6 months or every quarter to try to make sure that you're keeping up with things and to try to sense what you might need from a legal or insurance standpoint. And then, of course, the lawyer, who is not always one lawyer, but often different lawyers. And the point I wanted to make on number 6 is, if you are defending a malpractice case, you may want to talk to your appointed lawyer, the one who is actually working for the malpractice carrier and you at the same time, as to whether an independent lawyer should come in to try to get the claim settled more quickly. There is something very important that most physicians and many lawyers don't know about called the bad faith rules, which basically say that if there's a malpractice action against a doctor and the carrier could settle the action within policy limits, then if they don't settle within policy limits, the carrier is responsible for the excess verdict. So yesterday I was speaking with a physician. He thought that he was not able to do any creditor protection because he had a malpractice claim against him. And I said, well, what are your limits of coverage? $1 million. And have they offered to settle? Yes, they offered to settle for $500,000. And are you concerned about the case? Yes, I am. Well, all you have to do is write a letter to the carrier saying that you request that they settle. And then if they don't settle, the case law is very favorable to doctors that if there was a jury verdict above policy limits, the carrier is going to have to pay the excess verdict. And based on that, or based upon opinion letters from good lawyers indicating that there's really no exposure to him personally, we feel comfortable doing his estate planning. So that's those bad faith rules, and sometimes the lawyer industrial complex between the defense lawyer and the plaintiff lawyer, they get a little bit carried away, and some of these cases could be settled a little bit easier and a little bit faster if there's the proper pressure maintained. Now, number 7, have enough malpractice insurance. When a client comes in with $250,000 coverage and somebody's died or they're not going to be able to ever work again, there's a lot more concern than if that client has $1 million or $2 million of coverage. I think plaintiffs are going to file a lawsuit to get their 40% of $250,000, but if they don't have to go to court and they can work less and get a percentage of $1 million, there's a much better chance that the case will settle earlier. Now, there's a contrary view that they'll always accept the smaller limits, and I understand that view, and it's less expensive to have the smaller limits, but I have found that clients who really have these excruciating cases sleep better when they have the higher limits. And on page 8, raising the limits is not always as expensive as somebody would think. These are some indicative rates from January. These are competitive rates, but they are rates from full-service Florida-registered carriers. We are in the remainder of Florida. They're in the first section. Excuse me. And a $250,000 policy for an internist might cost $9,000 a year. If that internist decides to go to $1 million, then it might be $6,000 more a year or $7,000 more a year, which after taxes is like $4,500 to have 4 times as high of limits. In dermatology, it might be from a $4,000 policy to a $6,500 policy. So it never really hurts to ask. Another thing that some clients can do, and I don't think they realize it, it's more work for the agent, so they don't always tell the client about it or explain it. But you can have a $250,000 individual policy and then add another $250,000 policy, for example, for the practice company. So if somebody sues the doctor, the insurance company will pay $250 for the practice company and another $250 for the corporation. And that can be very useful. It's called a corporate policy. That can be extremely valuable if a doctor leaves the practice and refuses to buy a tail. Because if the doctor doesn't buy an individual tail, but you have a corporate policy, then the corporate policy will cover the past acts of that doctor for as long as the corporate policy stays active. So I don't think it's a bad idea to actually sit down or at least talk on the phone to your malpractice insurance agent once a year and say, hey, what's out there? I heard something about something called a corporate policy. What would it cost me to raise my limits? What's my deductible? You know, this is one of your most important assets, the malpractice insurance, so you want to be careful with it. Now, slide number 9, besides malpractice insurance, you do want to make sure you have disability insurance. You want to look at having overhead insurance. If you can't work for 8 or 10 weeks, do you have an insurance policy that would pay the overhead expenses? Do you have normal liability insurance if somebody trips and falls in the parking lot? Do you have workers' compensation insurance in case an employee gets hurt? Do you have unowned automobile liability insurance? If I ask my receptionist to run across the street to drop a package off at my insurance agent's office and she gets in an accident, guess who's responsible for that accident? My whole law firm. So that's why we have something called unowned automobile liability insurance, where we're covered if somebody's driving on our behalf and gets into an accident. And then, of course, for the car owned by my PA, we have umbrella coverage, and we've listed all the employees in our office who are permitted to drive my car, and if any of them are in an accident driving my car, we have an umbrella policy to protect the law practice, accounts receivable, furniture, and equipment. So these are things to talk about with the insurance company just to set up your lines of defense, because even if we do a good job of creditor protection of the medical practice, we want to have insurance as the first line of defense without a doubt. Now on page 10, just getting into this conceptually, we have the single physician-owned medical practice, and of course I notice a typographical error. This single physician has a spouse, so I'm not sure where that happened. Let me peek at number 11. Well, that would be multiple doctors. I see. So this is a solo doctor. The next time you ever see this slide is going to be called the solo doctor-owned medical practice. And there's the doctor, and the doctor doesn't have any partners, and the doctor has an LLC, which owns the medical practice. And then a patient who sues the medical practice cannot sue the doctor unless the doctor was negligent. So you want to definitely have a medical practice company set up, whether it's an LLC or a professional limited liability company or a PA. You want to have it set up. You want to make sure you're using it properly. So when the receptionist tells Mrs. Jones, don't worry about your headache, I'm sure you'll be better tomorrow, and Mrs. Jones ends up with a stroke that night, that the doctor doesn't have personal liability as long as the doctor didn't tell the receptionist to follow that kind of protocol. And then we show the car. We don't always have cars in the medical practice entities. I'd say only maybe 5 or 10% of them have automobiles in them. We gave a prior webinar on that subject. But some clients actually would set up a separate little LLC owned by the main LLC to own the car. Then we have, in this case, most clients would have one company that owns the whole medical practice and every part of the medical practice. But some clients want to divide up the liability. So for example, if this client had a sleep lab and was concerned about liability because who knows what the lab techs are doing with patients at 3 in the morning, and then this client has a diet center, and diet centers are pretty healthy, but who knows what sort of experimental medications might be used. I remember the old fen-phen days, and you're dealing with a lot of high-risk patients there, and then a separate company for the medical practice. So you would have some wall, if somebody got hurt in the sleep lab or somebody got hurt in the diet center, some wall before they could get into the medical practice. Now, the doctor, if he's a urologist or she's a urologist, there might be an investment in a lithotripsy company. A surgeon, or many doctors who do procedures have investments in surgical centers. And then there may be a separate company owning the building. And I would never put a building under a practice company. You always want to keep it separate. And you want to usually, most of my clients, I would like them to owe some money on their building and have a mortgage on the building. And I'll explain more about that in a little while. And the building would not be owned by the doctor, because if the doctor gets sued for malpractice, we don't want to have him or her lose the building. So the doctor may own the building company as tenants by the entireties with a spouse, or the spouse who's not a doctor may own it. And I always would put the building in a limited liability entity, because if somebody trips and falls in the building, I don't want the doctor and his spouse to be sued. So that's just a general picture. And of course, you've got some estate planning mechanisms going on that are beyond the purview of today's presentation. On to tab 11, maybe the doctor brings in a new partner. The new partner, quite commonly, they'll set up a subsidiary LLC, and the new partner may set up an S corporation, and they may share in an LLC, which is the medical practice. For the CPAs and lawyers on the call, if you're setting up a brand new medical practice for a single doctor, I'd like to set them up as an S Corp LLC owning a disregarded entity LLC, have the disregarded entity LLC get a tax ID number, bill Medicare, and then when it's time to bring a new partner in, you don't have to change entities. You just add the partner in, and the LLC becomes a partnership with the same tax identification number. Okay, tab 12. How can we take money out of our medical practice entity? And I'm assuming that the medical practice entity or the doctor's stakeholder in the medical practice entity is an S corporation. It's the most popular thing. It may be legislated next year to not be so popular, but that hasn't happened yet. And the safest thing you can do is make those payments out to the pension plan. If you've got a good plan actuary who's done a good census of the employees and has looked at all the different techniques that can be used, you might be able to really put more away for the doctor than you had ever thought you could. And that's where having a good plan advisor on the team is a great idea. There are good pension actuaries who will give proposals and not charge, and can give proposals that are just excellent that a lot of clients haven't thought of. How about children on the payroll? How many of us have children working in the office, and then the children might coincidentally make enough money that they can fund a Roth IRA, and then put that money in a Roth IRA? It's creditor-proof for the child, and it's going to grow tax-free for the child's entire lifetime. And the child has lower tax brackets than the parent. The next thing is wages paid to the doctor. There is a Florida statute which indicates that wages paid to the head of household, who's a bona fide employee, should not be subject to creditor claims. Now, you enhance that protection if you have an employment agreement in place. And if it's a small practice, a judge may not really believe it's wages. There's some case law that goes the other way. But typically, we recommend that a written employment agreement and a fixed monthly minimum wage. You can always take bonuses above that. And for pension plan purposes, typically doctors are taking about $175,000 in compensation. And then the rest may become dividends, because dividends are not subject to the employment taxes. You save about 2.2275% after taxes paying yourself in dividends rather than wages. But if it's a solo doctor taking money out of a company, taking dividends may subject them or the doctor to creditor problems if somebody has a creditor claim against the doctor or is ripe with a claim against the doctor. So that's where the doctor would typically sit down with a knowledgeable lawyer and say, well, how much do I take out in wages, and should I be taking dividends right now? I think a lot of the lawyers and the accountants know that if you could live on your dividends and bank all your wages, that may be the best combination for doctors who have present creditor concerns. Spouse on the payroll, Well, that's creditor protected if no one's suing the spouse, and a lot of spouses deserve to be on the payroll, but you do have those employment taxes. And then rent. Are you paying rent for use of the building, use of equipment? Who are you paying the rent to? And are you paying sales tax on the rent? And then finally, if you want to have a friendly creditor in front of the other creditors, then you might want to be paying interest to a family limited partnership or a spouse or somebody who's loaned money to the practice. That's tax deductible to the practice. It's not like a dividend, and it's not subject to employment taxes. So sometimes the friendly creditor is somebody who should receive a nice interest payment. Okay, some key practice creditor protection strategies. Number one, of course, keep your valuable assets outside of the practice. Don't even keep a whole lot of money in the practice. You know, maybe 3 or 4 months operating money is all that. You wouldn't want to store up $500,000 to $600,000 in an average one-doctor medical practice. Number two, and this is what we're going to emphasize in the next 8 or 9 minutes, is let the creditors of the practice get a first lien on the practice assets. And let the practice entity, if need be, guarantee debt owed to other entities to pledge its assets. Number four, you may enter into long leases with a related landlord, just to keep the plaintiffs out of the medical practice. Now, let me mention that what I'm showing you here, going to screen 14, for example, is not going to be successful against every single creditor who might challenge these types of programs. But the good news is that plaintiff lawyers in malpractice cases rarely challenge any program other than the program of getting their settlement money as soon as they can without working as hard as they have to. So oftentimes the plaintiff lawyer will sit down and say, look, I cannot accept policy limits unless I can reasonably assure my client that it would be hard to get anything above policy limits. I see the doctor's driving a Rolls Royce. Who owns it? Well, it's the doctor's spouse owns it. Okay. Well, I see some beautiful furniture, equipment in the medical practice. Who owns it? Well, the practice does, but they owe X dollars to such and such a bank because of a big building loan, and there's a 20-year lease, blah, blah, blah. The plaintiff lawyer's eyes glaze over, and the plaintiff lawyer will often say, okay, give me the policy limits. You know that. So while certain lawyers could look at anything that I might suggest and say this won't work 100% of the time, the result from that should not be don't try it. The result from that is I need some sort of shell because I'm a turtle without a shell now. So on page 14, the medical practice could borrow money from the bank. There's the bank down there. It loans money to the medical practice. The medical practice gives the bank a lien, which is like a mortgage on its accounts receivable, furniture, and equipment. Then the medical practice gives a bonus or a dividend to Dr. A bonus or a dividend to Dr. B, and they pay taxes on this if the medical practice is an S corporation. And the IRS ends up with 35%, and Dr. A and B end up with 65%, and Dr. A and B don't really like that program very much. Now, when they eventually retire and the accounts receivable go to pay off the bank, they won't pay taxes at that time, but that doesn't really help paying taxes now. So we go to page 15. This is more popular. It's not at all uncommon. Dr. A and Dr. B each borrow money directly from the bank. And in order to get a good interest rate and a good deal with the bank asks that the medical practice guarantee the loan and pledge its accounts receivable, furniture, and equipment in order to make sure that the bank's going to get repaid. And Dr. A feels better about that, and Dr. B feels better about that as well. Dr. A takes his or her money and maybe pays down the homestead mortgage. Dr. B takes his or her money and buys an investment and tenants buy the entireties with the spouse. The IRS doesn't get anything. Now, an auditor may not agree with this. An auditor may try to recharacterize this, but I've never seen that happen. And now, if somebody sues the medical practice, the bank is not going to let anyone have any assets that would otherwise be exposed here unless these loans are repaid. So if Dr. A gets a big malpractice judgment against him, the plaintiff's lawyer is not going to have any sort of easy route to get into the medical practice assets and would typically settle for limits or less than limits, taking this into consideration. Okay, now page 16, let's say that A and B and their spouses have a building. They have $1 million building. They owe $800,000 on the building. Well, the bank wants a lien not only on the building, but also against the medical practice assets. That way, if the medical practice shuts down and can't pay rent to the building entity anymore, the bank collects the accounts receivable, collects the furniture and equipment, gets what it can for them, and that reduces what the building entity owes. So, for example, if the medical practice has $200,000 worth of accounts receivable, furniture, and equipment, and the building loan is $800,000, the practice goes under, it goes bankrupt because of a judgment against it. The bank collects these things, and then the plaintiff lawyer doesn't get them. The bank gets $200,000, and now the doctors only owe the bank $600,000, and the doctors go find a new practice to work for. And that's why that's called cross-collateralization. That's cross-collateralization. So when doctors borrow money from the bank, or maybe even there's already a loan, it's not unusual to say to the banker, you know what, I want cross-collateralization with my PA assets because then it is less likely that my spouse and I would ever have to pay on the building loan beyond the monthly payments. Now, and that also does not result in any IRS issues. Going to page 7, I'm going to skip to page 19. This just shows it a different way, but this could be furniture and equipment in a limited liability company on page 19. And the practice, by the way, could sign a long-term lease agreement and give the LLC that owns the furniture and equipment a lien, like a mortgage, for its right to enforce the rent. And we do that with real estate leases all the time. So then if the practice can't pay its rent because it became insolvent because of a malpractice judgment or any other reason, the LLC accelerates the rent, the practice immediately owes quite a few years of rent, and the LLC collects on the furniture and equipment. Now, will that really work after 2 years of litigation in bankruptcy court? I don't know. But will that cause a plaintiff lawyer to be willing to settle a case? It's been very successful. Going to page 20, I just wanted to point out that some clients have an S corporation medical practice entity that has real estate in it or has valuable equipment, and we wish we could take it out, but we can't because we would trigger income tax if we tried to. What we're able to do, which a lot of advisors don't realize, is you're able to set up a new parent company which would own the medical practice, and then the medical practice company can do a tax-free transfer of the equipment and the real estate to separate entities. It keeps its tax ID number, it keeps its financial statement identity, but you're able to get those valuable assets out without paying income tax. So those are the primary ways to protect your medical practice assets. Now, please don't forget to protect personal assets. That's simply stated on page 21, and that would be a future webinar or a future checklist for you. And also, please don't forget to comply with medical law. This is just from a slide that was presented by a lawyer named Lester Perling, who I do a lot of work with to help us keep clients in compliance with medical law when questions come up. Okay, I'm going to answer some questions here. The first question is from my friend Bob, who's a lawyer who has taught me probably more than any other lawyer has. And one of my favorite sayings that he says is, for every simple question, there's a simple answer, and quite often it's the wrong answer. because complicated situations often call for complicated solutions. But in any event, Bob's question is, what is the consideration to the medical practice when it pledges its assets to secure the loan to the doctors or the building to avoid a fraudulent transfer issue which may void the lien on the assets? Well, I would call it an employee benefit, a legitimate employee benefit, and that as a practical matter, it's required by the bank. But I do acknowledge that you could have a creditor come in and say that it was not a legitimate transaction or that it was some sort of a fraudulent transfer issue. The point is that I don't know a better way to do it, and I've never seen a creditor try to do that. Okay, I have time for one more question, and that is, will a line of credit protect my assets and accounts receivable? And if you owe money on the line of credit and there's a lien on the practice assets, then that lien will come ahead of other creditors. But most clients just open up the line of credit and they don't pull on it. It's shown in the public records as a lien, but the bank isn't actually owed money. If the bank isn't actually owed money, it really doesn't protect you from another creditor. So then you go back to the slide that I showed where it might be better. I mean, there's no harm in having a line of credit in place, but if you pull on a PA line of credit and then pull the money out, you may pay taxes. So it might be better to do a low interest rate, longer term personal loan, the way I showed you. Okay, well, I will welcome further questions by email. I appreciate your participation in the webinar. I hope you enjoyed it, and we are very open for pointers and advice that you may give us on the way we're presenting these webinars. I don't know about you, but I like the fact that we don't have to drive to a seminar. We don't have any traffic issues. We can all be comfortable, and I hope that this was useful for you. Thanks to everybody, and have a great evening.